just had a hearing on that. That's like, so we need to go. What's this video? Huh? No, I don't want.
Oh, yeah. Court's in session. You may be seated.
Dr. Simon's representing yourself. I could speak for myself, but that's not really that.
We'll wait, right?
I can clear up a lot of confusion. About what these are. But I'm not sure that's the truth.
Back on the record, People versus William Simon, 182261. That's why I did find that question as for hearsay, so I'm not allowing that specific question.
Your Honor, can I respond to the objection? Okay. First of all, the question was, did Ms. Russell speak with Ms. Simon about the increase in responsibilities in her area as it related to the complaints from OCR, the 2011 Dear Colleague letter, and then the policy? That statement under 801C is not hearsay. It's not being offered to the truth of the matter asserted on whether or not Ms. Russell actually did have additional responsibilities as a result of those. It is being asked, it is being offered to show that the statement was made. The response to that statement, which would be from Ms. Simon, is also not hearsay under 801D2 of admission by a party opponent. And I'm not sure, does the court have that book? No, okay. Because basically under 802, the hearsay rule, it says if it's an out-of-court statement, which it is the out-of-court statement.
Talking about President Simon's response.
Right. That would be a party admission because it would indicate what she knew and what she knew. And so, as we've indicated all the way along, the increase in the pressure on this division or this unit and all the things that they had to do in the middle of all of this created that environment. And Ms. Simon, whether or not, and the objections all the way along with that, what did Ms. Simon know about? Well, then when I asked her question about starting down the path, they had questions about whether or not she knew about it. Now we're objecting, but we can't find out if she knew about it.
Okay. What was your name again?
Michael Gutierrez, Your Honor.
Gutierrez, okay.
Thank you, Your
Your
Honor.
response to first 801C.
Yeah, first of all, Your Honor, I would contend that
Can you come to the microphone?
yeah, thank you. The truth of the matter asserted is precisely what this is being offered for, I would contend. Okay, Mr. Teeter asked the witness, what did you say? And he didn't ask just what did you say, but the questions are going to come out on what was the underlying communications, issues, reports, documentation, who had conveyed certain things to the witness, which makes it layered hearsay, but so that's another exception, but or problem. But he's asking her specifically, based on the truth of what's in these documents, what's in these records, whether the truth of the matters asserted were conveyed to Dr. Simon. I contend that's a purely hearsay purpose.
Did you speak with Simon about additional responsibility taken on after the policy change in the Dear College?
And I would contend that the question is seeking the truth of the matters asserted in the Dear Colleague letter, whether they're accurate, whether they were conveyed, and all of that kind of material that is directly in the letter that he's trying to ask the truth of to what Ms. Russell conveyed to Ms. Simon.
No, and that's the problem.
The question is just whether she talked with Simon
Correct.
about the issue.
And my objection was on the line of questioning as well. I understand, did you have a conversation? It's not a hearsay statement, or a hearsay question, Mike. But when we ask about the contents, when we ask about where the information came from, what prompted it, I contend that line of questioning goes to the truth of the matters asserted in the underlying hearsay document.
First, Your Honor, those documents have already been admitted. Secondly is, again, the question was, did you speak with her? That is not hearsay. That is being offered to show that the statement was made. Any response by the defendant would be a party admission, a statement against interest that we're going to use to show when she was aware of certain things and what she was aware of.
Again,
It seems like such a non-issue because it's just so key, so central to everything we're talking about here. That I hate to get hung up on whether it's technically hearsay or not. It's certainly relevant.
again, my concern goes to the rest of the line of questioning as well. And the contents of the communications and statements, why they were made, what was the underlying document, was it conveyed? Those are where I expect Mr. Teeter to be going. That's where my objection is also targeted.
So we're objecting now before I ask the questions, Your Honor? I'm not sure that they're timing. The question that I've asked is not hearsay. The answer that's elicited won't be hearsay. If at some point in the future I ask one that would be hearsay, obviously counsel can object then. But to object now to what he thinks I'm going to ask down the road and the way I'm going to ask it is improper.
Okay, well,
Your Honor, one more objection. This is simply a 602 objection for the witness. This is lack of personal knowledge. There is no foundational showing to support the to support the witness's personal knowledge of certain communications. And the rule says the witness may not testify to a matter unless evidence is introduced sufficient to support a finding the witness has personal knowledge of the matter. I contend that is a foundational requirement. If we are going to go down the line of questioning, that foundation needs to be laid first pursuant to this rule. Then
the question is, did she say talk to Simon about it?
Okay, I'll raise the objection if he asks about the communication then.
Okay. Okay, well, one question at a time. I'm going to allow this one in and hope it doesn't end up with an objection every question thereafter. It seems relevant, very relevant and important, and to be moving in. Ms. Granberry Russell, you can come on back after yourself.
Your Honor, one other thing I want to bring to the court's attention, there is a sequestration order, and we've honored that. One of our witnesses, Marie Howell, is out in Darwin, whatever the way it is. But it came to our attention that she was watching some of this on live stream. Which of course is not a don't have until you have social media. We now instructed her not to do that, and I want to bring it up to the court's attention.
Okay, thank you. I've never heard of that happening before, but I guess it makes sense that that's where we're at.
Ms. Russell, I asked you the question of in your monthly meetings from 2011 to 2014, did you discuss with President Simon the additional responsibilities or the additional obligations that you had as it was a follow-up to either the OCR complaints, the Dear Colleague letter, or the new policy that was created in 2011?
There may have been general discussions at different points over that period of time about the responsibilities of the office. They may not have all been centered around Title IX, but there may have been general discussions about the needs of the office.
And when you say needs of the office, it sounds like you took on a lot more stuff after 2011. Is that correct?
The number of investigations slowly began to increase the more notice was out, so that would have placed more of a need for us to be responsive to those investigations or those complaints that were being brought to the office. But I can't tell you the amount of numbers or anything of that nature. I just don't recall.
If I understood you correctly, the 2011 Dear Colleague letter also set some time frames for your investigations?
Yes.
Okay, so you had an increase in number, but then you also had some specific time guidelines?
I believe they did call for, they said prompt and equitable time frames, but without looking at the Dear Colleague letter, I can't tell you the amount of time.
Let me show you what's been admitted as People Exhibit 31. Is this the policy that was adopted in 2011? Sexual harassment for MSU?
Yes.
Did you discuss that policy with President Simon before it was adopted?
It's possible that I did. I can't recall specifically if I did.
Who has final approval of that policy?
It states on policy history, it was issued by the Office of the President, and then it gives numerous dates.
Okay, and what was the last date?
June 2011.
So is that when President Simon would have signed off on it?
It states that it was issued by the Office of the President on that date.
Okay. Did you ever meet with her after that on implementing that policy?
I can't say with any specificity that I talked to her specifically about this policy after that date.
Was that one of the reoccurring items on your agenda? Is the implementation of that policy once adopted?
Without looking at my agendas, I can't say with any certainty that it was.
Well, if the President passed a new policy that overhauls your area of expertise, is it your testimony that you would not have had ongoing discussions with her about implementing it?
That's not my testimony. I'm saying I can't recall if I did.
Okay. Do you have any reason to believe that you didn't have some update, or you weren't updating President Simon on implementing the policy she signed?
There were a lot of updates related to the Dear Colleague letter. Some of those might have been discussed with her, I'm assuming, yes. But again, a lot of this effort regarding changes in policy, but the way that we implemented, the changes in policies were being led by the Office of General Counsel. The implementation of those policies were being supported through our office, General Counsel's office, and other offices on campus.
What were your responsibilities under the 2011 policy?
I was the university's Title IX coordinator responsible for coordinating our efforts under Title IX.
Okay, and that also included supervising all investigations under that policy, is that right?
It would have been providing oversight of those investigations, yes.
Did you comply with that policy from 2011 through 2014?
To the best of our ability, yes.
You specifically, not your whole unit.
When you, I'm not sure the question again, please.
Okay, if your responsibilities were to oversee all of the investigations of sexual assault or sexual harassment, under the 2011 policy. Did you comply with that policy from 2011 through 2014?
I was responsible for supervising the staff that had responsibility for investigating. I had an assistant director for institutional equity, and that was Christine Moore, who supported that effort as well.
Okay, but that policy requires you to oversee all of the investigations, doesn't it?
Can you point to the...
Page 6, Section 4, complaints in which an employee is the alleged, is it a harasser? Is that what that is? Yes. What does it say with regard to your responsibilities?
Investigations generally. Do you want me to read?
Pardon me?
Do you want me to read this section?
Yes. What are your responsibilities under that section?
It states, each complaint of sexual harassment must be evaluated with reference to the pertinent circumstances. On occasion, a complaint will be resolved informally. Informal resolution efforts are voluntary, and either party may request that a formal investigation of the complaint be commenced at any time. Informal resolution is facilitated by the Title IX coordinator and does not involve any requirement that the parties meet unless both parties request such a meeting and the Title IX coordinator determines such a meeting would be appropriate. Informal resolutions such as mediation will not be used to resolve sexual violence complaints. Other complaints will result in investigations, including interviews and the review of evidence, such as electronic and written material, if any exists. Both the complainant and the alleged harasser will be notified of the outcome of an investigation. If an investigation results in a determination that sexual harassment has occurred, the university will take remedial action, including, where appropriate, disciplinary action to eliminate the harassment and prevent its recurrence. The Title IX coordinator, in cooperation with the relevant university officials, will also confirm that the appropriate non-disciplinary remedies have been provided to the complainant and will monitor the matter to assure that harassment does not recur.
And did you have additional responsibility when it involved sexual assault?
I'm not sure I understand the question.
As the Title IX coordinator, did you have any additional responsibilities on the investigations if the underlying complaint involved the sexual assault as opposed to sexual harassment?
The responsibilities would have been similar, I believe.
Well, there's no informal process, right? There's no informal resolution of sexual assault complaints.
Well, I read that. It says other complaints will result in investigations.
Right.
Both
And those investigations are directly under your supervision?
It states further that, and this is assistance with processing complaints.
And it lists your contact information as the Title IX program coordinator?
Contact information.
Under Title IX coordinator? That's
Yes,
you, right?
That's me.
It lists Pauline Granberry Russell, your office, and your contact information?
it reports the contact information for filing complaints. That would have been the staff that were under my supervision that were located in a different building with a different telephone number, but I'm identified as the Title IX coordinator.
Number 4, complaints in which an employee is the alleged harasser. Could you read the first line for me?
Complaints in which an employee is the alleged harasser. Complaints of alleged sexual harassment by a faculty or staff member will be investigated under the oversight of the university's Title IX coordinator. Complaints made to the Title IX coordinator will be referred to the unit administrator of the alleged harasser, or if the alleged harasser is the unit administrator, to the unit administrator superior. Complaints made or referred to the unit administrator of the alleged harasser or the unit administrator superior will be processed by those individuals under the oversight of the Title IX coordinator.
And you were the Title IX coordinator?
Yes.
Okay, so those types of complaints were directly under your oversight. Is that right?
The processing of those would be under the oversight of us, but it also states that complaints that are referred to the unit administrator will be processed by those individuals in the unit under the oversight of the Title IX coordinator.
So either way, even if it's referred out to a unit, it's still under your oversight?
It states that the Office for Inclusion and Intercultural Initiatives will assist units with processing and investigating complaints of harassment. Depending on the circumstances of a particular complaint, the Office for Inclusion and Intercultural Initiatives may be the primary investigator of the complaint.
So from 2011, when that was adopted, through 2014, did you comply with that policy as the Title IX coordinator?
In terms of providing oversight as the Title IX coordinator of the university's responsibilities under Title IX, yes.
Did your office train other MSU personnel on this policy?
I'm going to object, Your Honor. We are so far afield here. What does training by I3 of other people at MSU have to do with the charges of whether or not Dr. Simon made a false or misleading statement to the police during her interview on May 1st, 2018? I think the answer is nothing.
Your Honor, with regard to the implementation of this policy, which created specific obligations by Paulette Granberry Russell, those obligations come into play when the May 2014 complaint by Amanda Tomashow gets filed. So when she filed the complaint with Dr. Coban, when she filed the complaint with Christine Moore, when Christine Moore reported that complaint to Paulette Granberry Russell, all of it was under this policy.
And so your question about training of other people
Right.
is connected to that.
Well, the question is if she, I can ask if she specifically trained on it, because obviously if she's aware of the policy and under her obligations under the policy. But second is to then put staff members on notice of MSU what their responsibilities were.
Dr. Simon is not on trial for other people having other responsibilities at MSU or being trained. So this has nothing to do with these charges, Your Honor.
Well, no, because there's not necessarily one path to Dr. Simon. It could have come through. I've heard about the general counsel being involved, Dr. Coban filing a complaint. Sometimes it's in the department that soon would be osteopathic medicine. I think there are other problems to Dr. Simon, so I think he's entitled to.
Your Honor, he's clearly entitled to ask Dr. Coban, did you ever discuss Amanda Tomashow's complaint with Dr. Simon? He's clearly entitled to ask anybody he wants, did you ever discuss Tomashow's complaint against Nassar with Dr. Simon? I am not disputing that. But that's so far removed from what we're talking about with this question, which is, did you conduct training on this policy with other individuals at Michigan State University?
Well, it sounds like that with training on this issue would be her job or the job of the staff underneath her, and therefore she would know who else could be following complaints, who would have the knowledge of the obligation to follow complaints under the Office of Civil Rights. So is that where you're going with that?
That's partly it, Your Honor. The other thing is as we've already talked about, with the Office of Civil Rights requiring these changes, which then, of course, it required the university to change its policy, did they inform everyone of sort of the new responsibilities under that policy? Because that investigation is still pending all the way through the resolution in 2015. Again, it goes back to, if the university did not handle this complaint correctly, then it created not only civil or criminal liability for subsequent victims, but it also created exposure because they were already under an investigation for not adequately investigating complaints of the violation of Title IX by OCR the same summer.
Okay, I'm allowing the question, so ask her again.
After the 2011 policy was adopted and was issued by the Office of the President, did you personally or your staff train the staff and employees of Michigan State University on their new obligations under this policy?
Yes, we did.
In fact, a lot of it, training went on after that, didn't it?
Object to the question is vague, Your Honor. I don't know what he means by a lot of training.
Well, I think actually I've heard about this before, so it's not really new information, but I think, if it was her or if it was Christine Moore talked about all the training that happened
Christine Moore, Your Honor.
Throughout the community on sexual harassment and sexual assault. So we know that's happened, but your question is too vague.
Okay, I can. Any idea how many trainings that you did over the from 2011 to 2014?
I don't have a number, no.
More than 12?
Yes,
More than 20?
I believe so.
Okay. In fact, did you train as many of MSU's employees as possible under the new policy?
During that period of time, we developed an online e-learning that was mandatory for all faculty and staff, as well as a e-learning that was mandatory for all incoming students at MSU. And there was some training was being done, peer-to-peer training for students was being done through the SARV program, or the Sexual Assault Relationship Violence Program. There was in-person training that was being done by staff of our office, as well as we may have other units that were providing some support for that, including through Student Affairs and through, at that time, the Women's Resource Center.
In early 2014, were you notified that the Office of Civil Rights was actually going to pay a site visit to MSU regarding the complaints that had been filed?
Yes.
Do you recall who told you?
The Deputy General Counsel at that time,
Who was that?
Christine Zako.
Do you recall approximately when you were notified?
No, I can't remember when. I know they were going to visit in, I believe, might have been late 2013 that we were notified, because I know some of the visits occurred, I think, in February of 2014.
You've been at the university since 1998, is that right?
Yes.
Had OCR ever paid a visit like this to follow up on, do a site visit investigating complaints during your tenure?
Under Title IX?
Yes.
Not to the best of my knowledge.
Is that a big deal for the university when OCR comes to do a site visit following up on an investigation?
It was the first, to the best of my knowledge, involving Title IX. Was it a, your word was it a big deal?
Yes.
I think in the context of all of the things that were going on, not only at Michigan State, but also throughout the U.S., with respect to the Dear Colleague letter and the changes that were being made and the number of colleges and universities that were under investigation at that time. The press, the higher ed press was reporting on it, so I think it was of note, yes.
Did you and Ms. Simons talk about the visit of OCR?
I'm going to assume that we did, but I can't recall specifically when or the nature of any discussions.
Would that have been the kind of hot button issue that you would have taken to Ms. Simon?
Typically, the hot button issue would be something that happened in that particular moment. Like I said, if there was a disruption or if I became aware of something that I felt I needed to bring to her attention at that time.
And so the OCR investigation site visit, would that have been one of those things you'd have brought to her attention?
I believe it had been brought to her attention by others because I didn't receive the notice until probably a week after the letter had come.
Okay. The cabinet, was it ever a topic of discussion in the cabinet that OCR was coming for a site visit?
I can't remember if it specifically was an agenda item. It's possible that it might have been discussed, yes.
Would you have brought it up at the round table or would Office of General Counsel?
It could very well have been brought up by the Office of General Counsel, and it could have been brought up by myself, but I honestly cannot remember if I did.
When they came, is there certain things that the university needs to do to facilitate their investigation while they're on site?
That would have depended on what they were asking to be able to do.
For example, in your area, we talked before about you having to produce the investigative files for your sexual assault complaints.
Right.
And do you know of any other areas that were directly affected by their site visit other than your office?
I remember they asked for a lot of different information, or we provided, even if they didn't ask, a lot of information that reflected the range of things that we had been doing since the issuance of the Dear Colleague letter.
And was that from multiple offices, not just yours?
Yes, that was multiple offices.
Including the Office of General Counsel?
I would imagine so.
Do you know how long they were on campus?
I think it was 2 or 3 days, maybe, a couple of days, 2-3 days.
If OCR finds that you're not complying with Title IX requirements, are there some negative consequences for the university?
In the regulations, they do talk about removal of federal funds, elimination of federal funds. I guess, obviously, the consequences are for them to define.
I take it from your saying it can go all the way up to and including withholding the funding?
Yes.
Is that why your office and Office General Counsel was so diligent in responding to the Dear Colleague letter and to the complaints? Was the possible consequences?
When this began, that was not that was not the motivation for making the changes. The motivation for making the changes, we certainly didn't talk about the elimination of federal funds because it wasn't a complaint. The Dear Colleague letter was an issuance of guidance to all of, public education on the things that they expected us to do to be compliant with Title IX.
But the 2011, 2012 complaints, those were actual complaints that they investigated,
Those were
right?
complaints.
Okay, and those could result in sanctions?
They could result in sanctions.
Did you meet with the OCR investigators when they came to campus?
I believe that I did, yes.
Were you interviewed by them?
Yes.
Did any of your staff meet with them?
Again, I'm recalling this was in 2014, I think. I believe that they did talk to the investigators.
So that would have been Amanda Garcia Williams and Christine Moore?
I believe so.
So you told me about case files, but it's your recollection that you don't know whether or not you had to provide a spreadsheet of your cases?
I can't remember if we provided a listing of the case files. I know that we were asked to provide them with the case files, but I don't know if we did a listing of those. I just can't remember.
Okay. Did you ever see the Title IX settlement agreement when it was finally adopted in 2015?
I was given a copy of the September 2015 report that had the resolution items that were identified in that, yes.
Did that also include some things that your office had to do?
Well, at that point in time, my office was the Office for Inclusion, and there was the new Office for Institutional Equity that was evolving at that time. So there were things that I was being asked to provide some support for while we were in that transition.
Did you also receive a copy of the OCR Title IX findings that led to that resolution?
I'll be honest with you, I thought they were both in the same document. I just don't remember two separate documents, but that's not saying they don't exist.
Let me show you proposed Exhibit 15 and ask you if you recognize this document.
Yes.
And is that the findings report we were just talking about?
This was their, it looks like the report of their investigation.
Let me show you what's marked as proposed Exhibit 16. Is that the resolution agreement that you've been talking about?
Yes.
So after the findings and Exhibit 15, did you have to continue to respond to the issues that OCR was not happy with?
I was being asked to provide some support in the coordination of some of these, not all of them.
Okay. And then on 16, the resolution you already indicated was sort of a combination of you and OIE as it was being created?
I'm sorry. I was referring to the resolution agreement in my first response
I'm sorry.
to you.
Okay, let's start that over. After 15, when the findings came out, did you have to do anything in response to those?
I can't differentiate between what I was being asked to do to support the findings of either the report or the resolution agreement.
Did they kind of roll into one?
I can't say that they did or they did not. I know that I was being asked to provide, to the extent that there was anything that was within my office. Now, understand that my physical space was in the administration building. Institutional equity, which was now under the oversight of an external person, was housed in Olds Hall, which was in a different building. And so between general counsel, the person that was heading up the OIE, and myself, and I would imagine others were involved in responding to whether it was the report or the resolution agreement.
Okay.
The work had been divided among many of us to respond to certain things, and that was being led by General Counsel's office.
What are the admission of closed exhibits 15 and 16?
Your Honor, we object. This is part of the things we addressed in our brief. A handful of reasons why defense objects. On relevance grounds, first of all, both of Exhibit 15 and 16 are dated a year and a half after Ms. Tomashaw's complaint. My understanding is Mr. Keeter has said that these are supposed to be used to show the atmosphere, the effect, the chain of events, which is what we've been talking about on all these objections all morning. This happened a year and a half after the pertinent time period was looked at. This cannot, it is a non sequitur, it could have any impact on creating a certain atmosphere or chain of events. These particular reports at that time. Second, these reports are addressed to the General Counsel, not the witness or Dr. Simon. And third, on the hearsay two hearsay objections. One, we briefed the issue of 7.6611B. That's MCL 7.6611B. The people say that that is a hearsay exception for essentially business purposes. That does not solve the hearsay within hearsay concerns of both of these reports about underlying complaints, underlying.
Oh.
Do you want to come up with this one?
Yeah, maybe be at the mic to the microphone.
Thank you. I'm sorry. Maybe I'll start over at the beginning, if I would. So again, we briefed these. The objection, first of all, is they're irrelevant. They're dated 1.5 years after the relevant time period, which is the time period of Ms. Tomashaw's complaint and the immediate aftermath there in the next month or so.
Do you know where they are in your brief?
Yes, Your Honor. One is Exhibit 10 on our brief, and the other, if I could find it. Oh, the pages of the brief, Your Honor? I'll be able to find it for you. I see it on the, let's see, 16, which again, as I referenced, is Exhibit 10 in our brief, which is the same exhibit we're talking about here. The relevance objections are set forth there on the timing. The relevance objections are set forth there on the fact that they could not have created any kind of atmosphere or chain or chain of communication that led to misassignment, because these findings came out. They were directed to the General Counsel's office approximately a year and a half after the time period we've been talking about this morning. That applies to both documents, Your Honor.
I don't find that relevant because we're here about something that happened in 2018. That may not have been true.
My understanding is the prosecution's arguing that they go to this chain of events that led to Ms. Simon knowing or not knowing something in 2014, as well as the atmosphere that made it more likely that something would be urgently conveyed or something like that. These can't go to those. These cannot go to the atmosphere in 2014 or Ms. Simon's knowledge in 2014 because they were not authored and distributed until 2015. So for
it goes to her decision to be truthful or not.
And that's fine. I just want to be clear. That's a conditional relevance issue. I want to be clear the purpose that they're trying to be admitted for, because my understanding is what's been briefed is that they go to the 2014 communication circumstances and atmosphere, and they didn't exist at that time. So that's the relevance objection on that purpose for admission. Second, these are hearsay within hearsay, and there is no exception for that. They contain multiple statements of other witnesses, of complainants, of other individuals, and I'm not aware of a hearsay exception that satisfies that. And again, the conditionally relevant piece, if it's relevant at all, we have to decide, and I just ask the court to describe for us what purpose it will be admitted for, and only on a conditional showing of what fact.
Okay, Mr. Teeter?
Thank you. I'm confused by the last part. I'm not aware that counsel has authority to order the court to explain its rulings and how. But so I.
Probably a wise thing to do.
Right.
I think we're just at the hearsay.
Okay. It's not being offered for the truth of the matter certain. As we've indicated over and over, that this is the investigation that was pending through the summer of 2014. It was the site visit that was occurring during the same time frame that the Amanda Tomashow complaint came in. And I believe the testimony has been clear that it required a number of agencies on MSU's campus, including her own, to do all kinds of other things to respond to this complaint.
So it's not really truth of the matter
No.
asserted, it's for who knew what.
And then what they had to do in response to
What
it.
was done to respond because of these exhibits. So I'm going to admit it as not being offered for the truth of the matter asserted.
Thank you, Your Honor.
Yeah. 15 and 16, you said?
Yes, Your Honor. You already indicated that you received some instruction on 15 and 16 from the Office of General Counsel. Do you recall that? And sort of what you had to do to follow up on these findings? Do you remember that question? I'm sorry. Let me start that over. When we were talking about this earlier, I asked you about how you found out about this complaint and then what you had to do in response to it. As I understood your testimony, that came from the Office of General Counsel?
Yes.
Okay. And that was Christine Zako, among others?
Christine Zako, among others, I believe, yes.
And did you discuss these findings and this resolution agreement with Dr. Simon?
I can't say with any certainty that I did, because there were obviously others that I think or I believe were having discussions with her, but I don't know that. So there may have been some discussion with her, but again, I was moving out of that role, and others were leading the university's efforts related to much of this.
The findings and the resolution, were those topics that were brought up at the cabinet meetings?
Again, I can't say that I remember specifically them being brought up in a cabinet meeting.
You don't know whether or not they were talked about?
I'm saying I can't remember if they were.
In the course of performing your responsibilities under the 2011 sexual assault policy, did you discuss Title IX investigations with the people who reported directly to you?
Yes.
And how often did you discuss those with Christine Moore?
I know it wasn't daily, but it would depend on. It would depend on if there was an issue or concern specifically, if we were finalizing a report or if she had questions. Christine Moore was the Assistant Director for Institutional Equity, so she was doing a lot of the day-to-day managing of the investigations, working along with the Office of General Counsel as we were making sure that our efforts were aligned with what we understood to be the Dear Colleague letter, et cetera. So,
well, let me go back. Did you have a standing meeting with Christine Moore?
We tended to have standing meetings, but
how often?
Probably at least once a month or every 2 weeks possibly, but I can't recall specifically.
Well, the reason I'm asking is because she was the one investigating sexual assaults or sexual harassment by staff members. Is that right?
Correct.
Okay. And you're the one under the 2011 policy that's responsible for oversight of those investigations, correct?
Coordinating our obligations under Title IX and oversight of the university's Title IX efforts, and I was her supervisor, yes.
Well, and your specific oversight over sexual assault allegations, correct, under that 2011 policy?
Yes.
Okay. So would you meet with her regularly to talk about her cases that would involve staff members committing sexual assault or sexual harassment?
We would meet to talk about complaints and the progress on complaints. We may not have gotten into all of the specific details on them, but generally she was a senior investigator and leading the oversight of the staff that we had in investigations. So I was relying quite a bit on her knowledge and expertise as well.
So you've testified that during 2014 you were still implementing the recommendations of the Dear Colleague letter?
Say the date again for me.
2014.
Were we implementing the...
Yes, were you still implementing those recommendations?
Well, we were continuing to make sure that we were, we were making adjustments in our trainings. We were making adjustments in procedures, our communications campaign. There were a number of things that we were doing. That was just an ongoing part of our role with respect to Title IX. Some of those would have been to test what we were doing against what was called for in the Dear Colleague letter. It might have been other adjustments that we were making based on our experiences. We were getting a lot of back and forth from federal agencies and the administration at the time. There were changes that were being made in the Violence Against Women's Act that required other adjustments. And so we were monitoring very closely what we were doing vis-a-vis the range of guidance and requests that we were getting at a national level. In
your July 26, 2018 interview, you said during 2014, there was a heightened kind of alert because of OCR. Is that a true statement?
Yes.
Okay. Do you use email at Michigan State?
Yes.
What's your work email address?
prussell@msu.edu.
Does MSU have a computer use policy?
I believe that they do.
Does it provide restrictions on sharing passwords, login information, those kind of things?
I can't say that it does or does not. I don't know it in that kind of detail at this point.
If it has a policy, do you comply with it?
I don't release my password, except at that time I would have given it to my executive assistant in order for her to access something if there was a need for her to do so.
And do you know if that ever happened in 2014? Was it Jennifer Mishner? Is that your administrative
Yes.
assistant?
Mm-hmm.
Did she ever access your system?
Yes.
Do you know how many times?
No.
Do you know why?
If I were asking her to access it to retrieve something for me, if I were remote and I didn't have access to my computer, I would ask her to do that.
Okay. And that was pursuant to your specific instruction?
Yes, typically that would be the case.
Does anyone else have rights to send email from your email address?
No.
Have you ever reported a breach or a hacking incident on your computer or email account?
A breach?
Right, or somebody came in and hacked your system and sent out emails on your behalf, or did something else to breach the security of your computer at work?
That's not happened to me to the best of my knowledge.
Okay. And if it did, would you have reported that to the IT people at MSU?
If I had known about it, I would have reported it to IT services.
So if there was an email generated from your email, you would have been the one who wrote that email?
There was occasion when I would dictate something to my executive assistant and ask her to send it from my email account so that people would be clear that it was from me, or sometimes I would have her send something on my behalf from hers, but with something that says this is being done on behalf of Paulette Granberry Russell.
That would have been, again, specific, or pursuant to your specific instructions?
Yes.
And do you know how often that happened?
No, but has it happened before? Yes. If I were remote and needed her to access something for me, I would ask her to access it for me.
Do you know if that happened in 2014?
Is it possible that it happened in 2014? It's possible. But in answer to your question, I can't recall. But I'm not saying that it didn't. I'm saying I
You
can't
can't recall
recall.
an incident in 2014 where you directed Ms. Mishner to send emails on your behalf?
Generally, it's possible, but I can't recall anything specific.
And were those logged in any particular way that you had dictated this particular email, or you'd had her send that email in from your computer?
It would. I would only say it would happen so infrequently. I don't know. I just.
Did you ever use a personal email for address? Or excuse me, start that again. Did you ever use a personal email address for work?
Yes.
And what is your personal email address?
I'm hesitating to say that with others here in the room, but it's achirussell@gmail.com.
How often would you...
Excuse me, Your Honor, just as a courtesy to Ms. Russell, in light of her concern, can we have some sort of instruction to the press that they won't report her email address, or the media won't report it in any way, please?
Okay, please. I don't think any one of us would want our personal email given out to the public. so let's keep that private. I'm not going to ask how to spell.
No, I wouldn't either. The how often would you use that personal email for work-related business?
It would be occasional. Usually what I do is if I were working on something at the office, if I didn't have there were times when I didn't have a laptop at home, and I used my personal computer. And I would send something. If I were working on a document, I might send it to myself at home so that I could finish the document. Sometimes if I were working remotely and if I had my cell phone with me, I had easy access to my Gmail account, and I might send something to someone from my personal email account.
So I take it from that you didn't have the ability to access your work email remotely and send items that way?
I'm sorry, say that again?
From what you've described to us, it doesn't sound like you have the ability to remotely access your work email, where you can send emails on your work email?
The university has, instructions for how to do that, but honestly, I did not typically do that with using my my smartphone.
Okay.
I do have a university laptop that I can work from home on if I need to, or when I travel.
And
And
the
you can
email
access-
addresses that you've given us, were those the same in 2014?
Yes.
So just so I'm clear, then you don't or can't send emails from your work email remotely?
Your question again? I'm sorry.
Can you send emails from your work account remotely? Do you do that?
Yes, I do.
And how do you do that?
Through my laptop. If I have that with me, and if I'm in a wireless environment, then I can send emails from my work email account to others.
Okay, and do you do that frequently?
Yes.
Okay, then I'm confused about why you would use your personal email address if you could remotely access your work email.
That's assuming I'm in a wireless environment where I can do that. If I'm not, then I may use sometimes I'm traveling in the car, and I have I don't have easy access to the university system. I just have not taken the time to fully understand how to do that. So, and because I have a laptop if I'm traveling, or an iPad if I need to use that to communicate back and forth with others if I'm working on something, then I will use those, whether it's my desktop, my iPad, or my laptop when I'm in those environments.
And did you have all of that capability in 2014?
I know I had a laptop in yes, in 14. I don't remember if I had the iPad, but I believe that I did. And then I have my desktop.
So were you also able to retrieve emails from your work email remotely?
If I were using one of those two that I identified, the iPad or the laptop.
In 2014, did you become aware of a complaint that was made against an MSU doctor?
Yes.
And was it filed with your office?
In this case, I'm assuming we're talking about Larry Nasser.
Did you have any other complaints in 2014 against a doctor that was filed in your office?
To the best of my knowledge, we did not.
Okay, so then yes, we're talking about Dr. Larry Nasser. Was that, you became aware of that complaint?
I did become aware of a complaint or allegations of possible violation of the university's, what at that time was the RVSM policy.
Of your what policy?
RVSM, relationship violence, sexual misconduct. At least that's the nature of it as I understood it.
Slow that down a little bit. Relationship violence?
Relationship violence, sexual misconduct policy was the revised policy, I think, that existed in 2014. There were changes in policy, in title.
With regard to that complaint against Larry Nassar, how many times have you talked about that since 2014?
How many times have I talked about it?
Yes. How many times have you been interviewed? How many times have you discussed it?
I've been interviewed 5 times.
5 times?
Yes.
And who are those with?
The first time was in 2017, in June of 2017. Then the other times were between May and I think either June or July of this year. May
Of 2018?
2018.
That first interview in 2017 in June, who was that with?
A lawyer by the name of Hogan, I believe was the last name.
Hogan?
Hogan.
Is that H-O-G?
A-N.
A-N? Who's that?
Well, I can't tell you who that is. I can tell you he was a lawyer that was associated with a review that was being done by Michigan State.
And how did you get notified you were to interview with that person?
I received notice of that through General Counsel.
After the one in 2017, then you said May, June, July in 2018?
Yes.
And who were those interviews with?
I think it was the Michigan State Police, and then the AG, and then I think there was one involving you and some other members of the AG's office, I guess.
So before you were interviewed by the Michigan State Police, how many attorneys did you talk with about the Nassar complaint?
It was just the one.
And that was this Mr. Hogan?
Yes. I think there was another person in the room, but I just remember a very brief conversation with him, I believe.
Do you know what the purpose of that interview was?
It was limited to 2 items related to when I became aware of the allegations against Larry Nassar.
You said 2 items. So when you became aware of the allegation?
Yes, there was 2 documents, or at least a reference to 2 documents. One of them, I believe, I was shown, but I honestly, I can't remember specifically. It was, we're now 2 years ago, but I do remember reference to 2 emails.
And did you have an attorney for you at that interview with Attorney Hogan?
I did not have an attorney with me.
And I think you covered this, but it was the Office of General Counsel who told you to meet with him?
Yes.
Okay. Were they present during that interview?
Honestly, I can't remember that they were. I don't believe that they were in the room with me.
When you interviewed with the Michigan State Police, did you have an attorney with you then?
There was one, yes.
And who was that?
I honestly cannot remember his name. I apologize.
That's okay. And where was that attorney from? Did you hire him?
I did not. But he was there with me, and I.
Was he from Michigan State?
No, he was an outside attorney.
Was he a firm provided by Michigan State? Or was he an attorney provided by Michigan State?
Yes.
And then you mentioned multiple meetings with MSP. Did you have an attorney present in each one of those?
Yes, I believe I did. Yes.
And then with the meetings with the AG, did you have an attorney present for each of those?
Yes.
In the interview with Mr. Hogan, you said they referenced some documents. Did you actually see those emails?
I know that there was at least one that they made reference to because it involved my personal email account. And I just remember, I believe they showed me the document because they asked me about the name of the email account.
And that was your personal email?
Yes.
Okay. When you were interviewed by the Michigan State Police, did they show you some documents?
I don't believe they did at the first meeting. I believe they may have asked me some questions at the second meeting, the third meeting. I believe they showed me documents.
So back to 2014, how did you become aware of the complaint against Larry Nasser?
This is almost 5 years ago now. My recollection, Christine Moore gave me a call.
Do you recall when you got that phone call?
It had to have been around, it was either the 15th, it's either the 15th or the 16th, but I believe it had to have been probably the 15th, thereabouts. Yeah, I know it was before any other communications on that.
What do you mean by any other communications?
There was an email that was sent to Dr. Simon on May the 16th.
And that was sent by you?
That was sent by me.
And do you recall that was sent before 8 o'clock in the morning?
Yes.
Okay, so is that why you say it either had to be the 15th or very early on the 16th?
Yes.
Because it was before you sent that email?
It had to have been before because I was not the person initially contacted.
If a doctor is accused of committing a sexual assault on MSU's campus, could that cause problems for the university?
Objection, Your Honor. The question is vague and ambiguous. That obviously must involve a lot of different factors.
Well, it's obviously.
Well, and then I'm going to ask the details of what kind of problems. But I mean, if the court wants to take judicial notice that doctors sexually assaulting patients on MSU's campus have horrendous consequences, we would be fine with that.
Certainly take judicial
Thank you, Alex. When you talked to Christine Moore on the phone, what did she tell you?
I don't remember the specific details of the conversation.
What's the general nature of the conversation?
Again, I can't remember the...
The question was essentially in the prior one, what did Ms. Moore tell you?
Right.
Okay.
So, Ms. Long, she says she doesn't remember. But if it, let me know.
That's fine. I'll object again if it comes. Thank you, Your Honor.
Okay, thank you.
Not asking you the specific words that she used. What was the nature of the conversation, and what did she tell you about? Why was she calling you?
Why was she calling me? That's okay, isn't it?
It assumes that why she was calling me was conveyed to her. So it's assertive conduct. It's a statement made. So I'll just renew my objection. It's a hearsay objection. It's an out-of-court statement made to the witness. Depends on what it's being offered to prove the truth of. My understanding, based on the briefing, is that the prosecution contends it demonstrates the information flow to Ms. Simon, and that Ms. Russell knew certain information. Okay?
Right.
Same thing we talked about yesterday, the information flow. The objection we have there is a 103B, 104B conditional relevance objection. This chain of events, this chain of communications, again, is subject to the ultimate link in the chain being established. And two, as I discussed yesterday, I won't get into detail, the 403 balancing component on it, but it is unfairly prejudicial and needlessly cumulative. If it goes to what information Ms. Russell had, Ms. Russell's here to testify about what information she had. We don't need an inference drawn from this hearsay communication.
Well, I don't think it's really prejudicial because, and we don't have a jury here. I think I can read things out. I do think it is relevant, and I am accepting.
Thank you. I'll repeat my question, Ms. Russell. Why did Christine Moore call you?
I don't remember having a conversation with Ms. Moore. I have to assume we did because there was an email from me to the president alerting her to allegations, but I don't remember having the conversation with her.
And in your communication with President Simon, that was immediately after your phone call?
I don't know if it was immediately after the phone call.
Okay, well, if it was either late the 15th or early the 16th, it had to be pretty shortly before your email. Is that right?
I can't recall a phone call, and quite honestly, it wasn't until I was reminded of a document that I made some assumptions that there must have been a call. I just don't remember a call. I don't remember anything discussed in that call. I don't know what time. I don't remember the day. All I know is that at some point I was shown an email that would support that I had to have been told something, and that had to have been from Christine Moore.
Right. The information you conveyed to President Simon in an email, you didn't make that up, right? That's what Ms. Moore told you?
Well, and again, I don't know the detailed information because I have no recollection of it. I've given you the best answer that I can.
No, my question was, you didn't just create the incident that you relayed to Ms. Simon in that email.
I don't think she's answered that.
Whatever you put in the email was in response to the conversation you had with Christine Moore?
Objection.
So where were you when you took that call?
I don't remember. Again, I've indicated there must have been. I didn't remember anything until I was shown or advised that there was an email at these different points. But the first time, again, was in 17 when I was asked about it. And I can only assume that there had to have been a conversation.
Well, if we go back to the 2011 policy and your obligations to provide oversight on investigations that included staff sexual assaults, then Ms. Moore contacting you would be consistent with that policy. Is that right?
It would not. It would be consistent, but it wouldn't. Nor would it be inconsistent. I mean, I didn't always get a call on all cases, to the best of my knowledge. But yes, I would get calls on cases. But again, I can't say that with every single incident that was reported to the office that I got a phone call.
No, but the one that involved a doctor apparently was big enough to prompt an immediate call or a call quickly to you, right?
She doesn't remember she got a phone call.
I'm going to object, Your Honor, to this entire line of questioning about the call and the communication with Ms. Moore under Rule 602. It says a witness may not testify to a matter, that being the call or the communication, unless evidence is introduced sufficient to support a finding the witness has personal knowledge. She's been asked multiple times. She said she doesn't remember it. She doesn't remember the day. She doesn't remember the call. So,
I agree.
thank you.
So let's move on.
Do you recall whether or not you gave Ms. Moore any specific instructions on that call?
Same objection, Your Honor. She doesn't remember the call. She doesn't remember the day. She's already just...
Ms. Moore sent you an email later that day. Did you instruct her to do that?
I may have instructed her to do that.
And what did you do after that call?
Again, I'm not understanding the question because...
Well, you already testified that
Just a
you...
minute.
Oh, I'm sorry.
Are you saying after the call she doesn't remember?
Correct. And what I mean by that is you already testified you sent an email, right?
Testified she sent an email to
President
Dr.
Simon.
And now she's testified she believes she asked Christine Moore for an email about the subject. What
Right.
more are you going for?
Well, that's what I'm asking. What else did you do?
Objection, Your Honor. The same reason the witness has already testified she doesn't even know what day of communication happened. Mr. Teeter's question has the chronology, the timeline. What did you do next? She has said she has no personal knowledge of the timing of the call.
Your Honor, my question was, what did you do? I didn't ask when.
I think the question's broader now. So we know solicited an email from Christine Moore. We know personally sent an email to Dr. Simon. And that question is for us.
Mm-hmm. Yes, Your Honor.
I was not in the office on the 16th. Certainly not for most of the day. That was a Friday, and I was at a track meet of my daughters.
Do you recall when you went to the track meet?
It had to have been in the morning because it was in Kalamazoo, and it was the regional competition that she had qualified for.
And so you're at the track meet.
And I believe that I must have talked to Christine Moore, at least I believe that I did, because she sent me information on my Gmail account with some of the details regarding the complaint or the allegations that she was aware of.
What else did you do in response to your contact from Christine Moore? You mentioned the email.
You mentioned you may have asked her to send an email to you. What else did you do, if anything?
Usually when we get allegations, then we notify the unit administrator and make them aware of the fact that there are allegations of a violation of the university's policy. And I believe that I may have done some follow-up on that.
When you say follow-up, would it have been a phone call or an email? Some type of contact?
I believe, and again, this is recollection, that I may have done a phone call, a follow-up with the unit administrator.
Who is the unit administrator in this investigation?
That would have been Dean Strample.
Why was it Dean Strample?
He was the dean of the College of Osteopathic Medicine, and we usually reach out to let them know that our office has received allegations, and we notify the unit administrator of that and the expectation that there be cooperation. And I believe that I made a call like that.
From that action, would it then be our understanding that you knew it was the doctor in the College of Osteopathic Medicine after your phone call with Christine Moore?
Yes.
Otherwise, it would make no sense to call Dean Strample, right?
Correct.
Okay. Let me show you what's been marked as proposed Exhibit 7. Do you recognize that document?
This is the one that is dated, yes, I do.
And what is that document? Describe it for the record.
It's an email to then President Simon from myself, Friday, 5/16/2014, 7:56 a.m. Subject incident. We have an incident involving a sports medicine doc.
And what email address did you send that from?
This would have come from P. Russell, my MSU account.
Move the admission of proposed Exhibit 7.
No objection.
What was the date and time of that email?
Stated Friday, May 16, 2014, 7:58:56 a.m.
This might actually be the time to do that then.
Now?
If you want to, yeah.
Okay. We'll break and come back at 1:30.
Thank you, Your Honor.
Thank you, Your Honor.
Yeah, so it was what, 10:15? 10:30? Yeah, we came back to 10:30 until like 11.
That's actually Rashida.
Once we got to that point, it didn't say that specifically.